do any until you fix it, because Judge Levy doesn't have it, right? Okay. And was that okay? Well, but all the justices moved, so we need to switch all the cups together. Let me go get them all. I mean, like,
Hey Robert, can you hear me? Sound check 1 2 3 4. Sound check 1 2 3 4. Hey Rob, can you hear me? Sound check 1 2 3 4. Sound check 1 2 3 4.
there's an extra mic up here for Justice Zamora. I don't know if you want to have it there.
Put them like right here.
Yeah. We'll move it back.
Yeah.
For better audio.
That's why they sound so low.
All right, I'll let them know that we're gonna try it.
But you ask them, and if they say no, then we'll just leave it at that.
I won't be able to get in there until they're done deliberating this case.
They're just gonna ask you like this, just to say no, it's here.
Yeah, the chief is recused in this case, so we have a designated judge. That will be in this case, yes. So she'll be at the end. Yes.
She said possibly, she's okay. Judge Barnes is pretty good. Judge Justice Steele Mic check, testing 1 2 3. 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 Mic check, 1 2 3. You can't hear me. Mic check, 1 2 3. Testing 1 2 3. Testing 1 2 3. Testing. Mic check, 1 2 3. 1, 2, 3. Mic check, testing 1, 2, 3. 1, 2, test 1, 2. You do one, was that?
Mic test, mic test. The feedbacks.
We're getting
Doing it
that,
again.
we're getting that repeat again.
It's repeating to us like it did the first time.
Test 1, 2. But it seems like it's only out of your mic. Test 1, 2.
Test 1, 2, 3.
We're getting that feedback again, where she speaks it and then 3 seconds later repeats it. So testing 1, 2, 3. Oh, okay, then you're in.
Chinese white ones? Yeah.
I think it shoots the speaker's voice to them.
Okay.
This one, because I guess sometimes they can't hear. Yeah, so this one shoots the Chinese voice to them.
Okay, because I saw them moving keys over there.
And
they
that's for when they're
For each
speaking.
one, yeah.
Yeah,
Because they were saying, be careful, quiet, so they can't really hear.
yeah, and sometimes when they talk,
Mhm.
this thing moves when their voice is like loud.
Mhm.
And today it was very heavy. It was mostly like on the first line, and it shoots up.
Yeah, it'll go like up high when it can
Yeah.
like detect it.
This one.
Yeah.
And when the attorney was speaking,
The Honorable Supreme Court of the State of New Mexico.
Thank you. Please be seated. We'll call the case of State versus Logan, our case number 39191. Would counsel please enter their appearance, beginning with the petitioner? And you've reserved 25 minutes, correct? Okay, thank you.
John Floss, on behalf of the plaintiff respondent, the state of New Mexico.
Harold Galloway of the Elementary Mexico Victims' Rights Project and National Crime Victims Law Institute.
And you've reserved 3 minutes, 30 minutes?
Yes, sir.
Thank you. Okay, and before we proceed, an order should have gone out advising counsel to please be prepared to argue United States versus Bikundi and United States versus Kerry. Did you get those orders and you're prepared to do that? Okay, thank you.
Yes, sir.
You may proceed.
Good morning, and may it please the court. In this appeal, we ask the court to clarify the burden of proof the state must meet under New Mexico's restitution statute when seeking restitution in a criminal case. As the state now concedes, that burden is a preponderance of the evidence. That is more likely than not. This was not the standard imposed below, and the district court acknowledged the state did not even meet the murkier, lower standard that it was operating under at that time. And so to come up with this massive restitution award, the district court shifted the burden to Mr. Logan without notice. As Justice Vigil just mentioned, prepared to address the 2 federal cases that the court asked us to address, and I will begin there in my argument of urging reversal. So both Kerry and Bikundi, they call it different things, but it's the same concept. In Kerry, they call it systematic fraud, and in Bikundi, they call it pervasive fraud. And the point being, the fraud infiltrated the defendant's activities so pervasively that it was impossible to separate the legitimate services from the illegitimate services. And in both of those cases, there was, of course, a lack of record keeping, but also other evidence such as forging of documents and falsifying records. And that the facts themselves are different than what we have here. The court down below, the district court in the Logan case, did not provide or did not find that it was so pervasive that it affected every payment during that period. Instead, it separated them out into categories of payments. It found some checks could be related to legitimate services, primarily seems to be based on what was written in the subject line of those checks. And then it said it found another large chunk of money, found that the causal relationship for that amount cannot reasonably be tied to legitimate services. And that's where it switched the burden from the state.
Did it though? Because I'm wondering, let's take the federal cases aside. That was Federal Victims' Rights Act. And they have different language than we do. Just looking at New Mexico law, why couldn't the judge make reasonable inferences from the testimony and evidence before it? In other words, we knew that there was a record-keeping requirement for the trust. We knew that certain law or regulations for mental health providers required regulations. We know that the defendant admitted to that particular time period that he committed fraud, not just part of it, but all of it. With all of the facts and evidence, and there's a lot more, obviously, that the district court judge put out. Why couldn't the court make a reasonable inference from the evidence available that during those time periods that the defendant, in fact, admitted to, there was fraud based on all of the inferences? I think the other ones he kind of took out and said, oh, there's some other explanation. But with all the evidence, I mean, there was evidence he was only there once or twice a week sometimes, and he believed that evidence over the girlfriend's evidence. Taking all of the evidence together, could you reasonably infer, the judge, that in fact fraud was committed in these particular transactions?
I think I have 2 parts to answer that question.
Thank you.
The first part is, I think we have to take the district judge at his word that it was murky. I think the exact language was the line between legitimate and illegitimate services are murky at best, and that is in his order. And so he admits that he cannot find a causal connection for fraud or those other ones, or at least the state didn't prove it. And that's why he uses these federal cases and federal laws to burden shift. So I think we have to take him at his word that that's what he did. The second part about the evidence, and I think why he thought he could not, the state did not meet its burden, he had to burden shift, is the two of the witnesses that the state put on to talk about when Jim was there and not there and Claire was not there had problems with their testimony that I think that the court recognized. And one of those is that Jim Logan was doing a substantial amount of work for John that would not have involved being present with John. And a lot of that was managed care. And I'm happy to give you some cites to the record if you want, but it included finding and managing quality caregivers to stay with John.
Who's in the best position of knowing that information?
Of knowing the
legitimate purpose. It's your client,
yes,
right?
Correct.
So that, to me, is the core of Facundi, whether you want to apply the language of the Federal Victims' Rights Act. It is in a fraud case in particular, not just all restitution, but fraud. The person that commits a fraud, and this is true in civil, False Claims Act, there's leniency in the pleading in civil cases because the person who commits a fraud is in the best position of knowing whether or not it was provided for a legitimate purpose. So it's not burden shifting. It's saying if you have a legitimate purpose, the state still has to prove their case. You have this information, you put it forth.
Again, I think I have two responses to that. One, I do think that that's an accurate reading of the two federal cases and why they do that. The problem is, of course, that the Mandatory Victim Restitution Act reads very differently from New Mexico's restitution statute.
Actually, it does it, 39171B. And I didn't see this, and I don't want to quiz you on I'll let you get the statute out because I hate these kind of questions where you have to memorize it. I'm going to read to you the last two sentences. If the defendant believes that he will not be able to make any restitution, he shall so state and shall specify the reasons. That's so you don't have the money, I'm not going to make restitution because it's not punitive. Next sentence. If the defendant believes that no person, including the victim, suffered actual damages as a result of the actual damages, which is the damages that you pay restitution on, as a result of defendant's criminal activities, he shall so state. How is that not clear?
It does say that. I will also point out that that is in section B, is in a section about drafting the plan of restitution. And the plan of restitution would necessarily come after the restitution hearing. So I feel like B is a little bit unclear in that way.
Here's my plan. It was a legitimate purpose. I'm not paying $200,000 on count 45 because it was a legitimate purpose.
Jim Logan's point was he stipulated to around 36,000 plus of fraud. And so he was essentially saying the other was a legitimate purpose. I admit that 36,000 was causally linked to fraud.
Doesn't he have to explain what the legitimate purpose is?
I think the defense did put on evidence as to that, but I don't know that they're required to. I think this under our statute, under New Mexico statute, the state was required to prove by a preponderance of the evidence that the payments were causally linked to fraud. And I think that where we get that from is 39171A2, which defines actual damages as what a victim could recover against the defendant in a civil action arising out of the same facts. So perhaps there's leniency pleadings and things like False Claims Act where it changes a little bit, but in a civil action, the victim would still have to prove up their damages and the amounts.
But that's not all the state has to prove, let's take count 51, fraud over $2,500 or 70 some odd counts. In on or about the 30th day of January 2015. That's pretty specific, and your client pled to that count. So now you're saying we're going to have a mini trial within this count to say, let's see what over 2,500 is a legitimate purpose, and the state has to prove that?
What the plea deal said was, if I'm recalling correctly, if after the hearing it was determined that there was less than $20,000 in fraud, he was going to withdraw his plea. But in the alternative, he admitted to $36,000+ in fraud, is what I think the plea agreement ended up saying. And I think part of the issue here is absolutely this makes it hard for the state to prove, given the facts of this case. I don't know that every fraud case would end up this way, just as a practical matter. So if you think about it, there's two ways to get to the restitution claim, right? You either have a guilty plea, or you have a full-blown trial and you have a guilty verdict. If you have the guilty verdict, well, then you have tons of evidence already about what the fraud was and who paid what and why, and you have it beyond a reasonable doubt. So in that case, it wouldn't be like this, where you don't have the kind of record that exists here after a plea.
That's a different question from the restitution. Restitution is the remedy, right? It's not automatic necessarily in that circumstance where there's a guilty verdict, the restitution is going to be ordered under the act. Is that correct?
That's correct, but it could be.
And in other criminal cases in which you're arguing mitigation of the penalty, any other case, don't send my client to jail for 20 years for robbery, and I'm going to argue mitigation. Does the state stand up and say it's my burden to show why those mitigating factors don't exist? I don't understand why there's a difference in these restitution cases.
I think it goes again back to the plain language of the statute, which says restitution is full or partial payment of actual damages to a victim. And it defines actual damages as damages which the victim will recover against a defendant in a civil action. That would be a preponderance of the evidence standard.
What about let's go back to the federal case. Does the language in the federal statute states the burden of proving the amount of the losses borne by the government? And then it goes on to say, but the burden of demonstrating such other matters as the court deems appropriate shall be upon the party designated by the court as justice requires. We don't have similar language in our statute, do we?
We do not have anything like that in our statute.
And so tell me why we should not adopt something similar in New Mexico as they do in the federal courts, aside from the language, which is concerning to me. But give me some other arguments.
It absolutely could be adopted in New Mexico, but that would be the purview of the legislature. The legislature had wanted that in there, they would have written it, but they didn't. They analogized it to civil actions.
But isn't it our realm to decide what the burden of proof is? The legislature doesn't decide that. Normally, we decide what the burden of proof is in any case.
Sure, yes, but here we're talking about the legislature specifically saying how they wanted restitution to be determined. And so you could decide the burden of proof, but what they've specifically said is like a civil action.
So we decide whether it's a preponderance of the evidence, but we don't decide. You think it's the purview of the legislature to decide whether there's shifting in the restitution hearing?
That's the position, correct?
So,
Go ahead.
sorry. So if the court, if the position was that, or if you felt that the court had found by a preponderance of the evidence that fraud existed in that 400 and some odd thousand, then what would be the defendant's job to show the court that there wasn't a preponderance of the evidence? I don't understand what actual meaning you're giving to the 31-17-1B last sentence, that if the defendant believes no person suffered actual damages as a result of the defendant's criminal activities, he shall so state.
I think that relates not to the hearing itself, but to the report that happens. And if you look, there's a couple of sections that relate to this report that has to be done between probation, parole, and the defendant. That's one of them. And then if you go look at E, they talk about, again, about a plan of restitution, and that happens, of course, after the hearing. So I believe it's a little confusing, but given that it's separated out, I believe that's what they're talking about. And if you're talking about a civil action, then it would be the same as any other civil action. The plaintiff proves up the damages, and the defendant has the option to either refute that evidence, or they can say nothing at all and say the plaintiff just didn't meet their standard.
So then what effect does G have that says at any time during the probation or parole period, the defendant or the victim may request the court grant a hearing on any matter related to the plan of restitution? I mean, if the defendant is not voicing at the time restitution is ordered, he doesn't agree with restitution, and why he doesn't agree, then how is there a determination made on restitution?
He did say he didn't agree. The why, I guess, gets a little more complicated. Again, the defense did put on evidence of what legitimate services Jim was doing. And again, going back to what's actually in the record and why I think the district court here was so troubled is because the two witnesses that the state put on were talking about not seeing Jim Logan. And again, Jim Logan was doing a substantial amount of work that would not have involved him being
There was
seen.
no evidence of him. It's what he didn't do is also concerning though. And that's evidence. He did not, allegedly he did all of this record keeping or made phone calls or managed the care, but there's no records of it. And the lack of records and the requirement that there be records for both I think it was the trust and his job as a mental health worker. In either event, the lack of records, the failure to do what you're supposed to do is evidence. I mean, in my mind, I don't even know that we got to get into this burden shifting. I really, to me, and it was in the state's brief, they argued with the evidence they had, and their position is it was ample to support the judge's decision. And I think we always forget that it's the failure to do what they were supposed to do is also evidence. And I just wondering why there's not enough here. Forget all the burden shifting and everything else. Why is there not enough evidence, as the state suggests in their answer brief?
So the first thing about the requirements to keep records, one of them was a regulation, as you said, and one was a trust. We argued down below that, and we maintained it on appeal, that the trust document didn't have anything to do with this because they weren't claiming money was misused from the trust. And then the regulation, the state didn't put on any evidence that Jim actually fell under that regulation. And so going back to, again, what the testimony was, the two witnesses, which were Tony Otto and Brian Wicksberg, Brian worked for them for 2.5 years, from Friday afternoon to Monday mornings, and he said it was fewer than 5 weekends he didn't see Claire and or Jim. And Tony Otto only worked there for 7 months, but also saw them repeatedly each week. So none of these witnesses actually cover the time period. And when you actually look at what the evidence presented was, most of it by the defense, it's that he was finding and managing caregivers to stay with John.
Can I interrupt?
Of course.
I think Justice Amara's point is well taken. I'm looking at the order of restitution. Paragraph 48. The court does find a causal relationship between defendant and $406,229.75, which includes the following. The biggest is $353,037.75, which cannot reasonably be tied to any legitimate services by defendant. Now, if fraud is converting property of another to your own use, and you're not entitled to it, the state, it seems to me, by saying the defendant received this amount of money, and the state says there's no basis for him being able to, there's no basis for him having a right to that money, that ipso facto is fraud. So I think the question is whether or not there's substantial evidence to support that finding, that amount, that amount of money cannot reasonably be tied to any legitimate services provided by the defendant. And the same thing can be said for everything else. Now, the next two paragraphs, for example, specifically say, you got these checks for these purposes, and the evidence is it wasn't applied to those purposes. Then paragraph C is the same thing. Paragraph D, paragraph 49, as it relates to Jonathan Coswell, he says, you got these checks for taxes, they were never paid. So I think, you know, there's nothing showing, I mean, you can't say that the defendant did not come in. You can, as to those, for example, you don't require the defendant to come in and say, but I did pay it. The evidence prima facie is that it wasn't paid. The evidence prima facie as to the 406 is that there's nothing in the record showing he's entitled to it. That is fraud. And I think that's a prima facie case. What am I missing?
I think 48A is the most troubling part of the court's order here. And this is what we've been alleging all along, and what Judge Lovelace says in his order is what he's burden shifting again to
It's not burden shifting.
And
please, I'm looking at it as a prima facie case. There's nothing here showing he's entitled to this money. That's not burden shifting.
I think if the court decides that's what the law is going to be going forward, then Jim Logan deserves the right to have a rehearing under that standard. No one down below thought that was the standard. In fact, the record is replete with the judge telling the state, but you have the burden of proof. What's your theory of fraud? What's the misrepresentation? You have to tell me. You're not telling me. And if you look at the briefing that occurred right before the restitution hearing, the same thing. The state and the defendant all agreed. They were operating under Rodriguez, Madrill, Lack, and Ellis, which is not this standard and is not the one that you're suggesting to be adopted now. So if the court is inclined to go that way, we would ask that Jim Logan have a hearing where he is on notice that that's what the law is and that he can be prepared to meet that burden.
Can I ask you one more question? So getting to Justice Thompson's point about the last sentence of paragraph B, the defendant didn't testify. He chose not to testify, to give any explanation. So he's saying, you accuse me of fraud, but I'm not good. And you allege and demonstrate prima facie that I'm not entitled to this money, but I don't have to explain nothing about it. And even if he did, assume he did. Let's not assume that he did. I'm thinking of in rules of evidence, hearsay. And this is off the top of my head. You're out of time, but you're fine. The hearsay rules provide that if you knowingly procure the absence of a witness to the point that they are not available to testify, and the state can establish that witnesses' hearsay statements are admissible substantively. And does that not fall within the realm of a civil action under subsection B?
Well, first of all, my understanding is that the rules of evidence don't apply in the same way to restitution hearings. That's why
They're more lenient.
Right. That's why you have all the hearsay coming in about what Shirley Cashwell said. I think the problem with that is I don't know that Jim purposefully made Shirley Cashwell not appropriate. And as for him, his Fifth Amendment rights were still attached at that point. So he still was operating under his Fifth Amendment right not to.
How's that? He did a plea. It was accepted, correct?
Correct.
So where's the Fifth Amendment?
So I can't remember the cites off the top of my head, but it's in my reply. In our reply, the cites about when the Fifth Amendment right detaches, and so under the laws, I understand it they're in place right now for Mr. Logan as we're on appeal.
But of course, his admission at the plea hearing is all admissible, which is to the dates and the crimes he committed. And
The date range.
The date range. Yes.
The date range, yes. Yes. I would like to go back to the evidence that I think that troubled the district court judge so much. I just want to point out that, again, that he was managing these caregivers and firing and hiring them, deciding they weren't good enough and getting new ones, including finally getting someone who worked well, which is this Brian Wicksberg, who they had for 2.5 years. But that was after hiring and terminating several, one home care assistance company and several individuals. They also manage his medication and medical appointments. Jim would call the doctor and arrange those. They handled his meltdowns and emergencies. There's a time when
you say they, I want to really separate out what he did versus Claire, because Claire, the judge didn't reduce what she was paid at all. So I don't think her services count towards, what he did or didn't do. He didn't reduce her portion at all.
The part of the problem with that, and if you look on paragraph, okay, see, I'm out of time.
Please take your time.
The court notes in, let's see. Apologies. In paragraph 22 on page 7 of the report, record proper page 314, that Claire wasn't involved in any of the money issues. So it got hard for them to separate out who was paid for what when, because the evidence came out in the hearing that she would make out checks to either Jim or Claire without reference to who was doing what work. She wasn't even separating it out at the time. So I think that's part of, I think the court really, really struggled with this. And that's part of the reason. And I will not take up any more.
Ms. Douglas, I do have another question. Does this case raise the issue of the distinction between the burden of production and the burden of persuasion?
I don't know if I know the answer to that, Your Honor. Thank you.
Thank you. Mr. Klaus.
Thank you, Your Honor, and may it please the court. Now, there's already been a lot of talk about burdens and burden shifting. I'd like to start by zooming out a bit to highlight that a party claiming abuse of discretion has the heavy burden of showing such error. And in this case, defendant does not carry that heavy burden. The record in this case amply shows that for its restitution determination, the district court reiterated and applied the proper legal standards, which are well settled in New Mexico, and properly held the state to its burden to make an evidentiary showing regarding restitution. The state's restitution case alone provided testimony and other evidence from which the district court reasonably could infer, as Justice Zamora was pointing out, that victims did not receive the benefit of roughly $353,000 that defendant charged for the in-home care he claimed to provide. Now, defendant had his own view of restitution that he wanted the court to adopt, and he presented that pursuant to 3117(1)(b), as Justice Thompson was pointing out, which indicates that a defendant shall so state his position on restitution. Specifically, he claimed that he would show that the work paid for, quote, was done. With that, the defense took upon itself the burden of convincing the court that defendant's view of restitution, rather than any other, was the view that the court should adopt. Under the circumstances, and this gets back to what Justice Zamora was pointing out again, it was not unreasonable for the court to consider the absence of reasonably sufficient documentation on the nature and amount of services billed as a factor relevant to the determination that such services were not legitimate and such services were not services for which defendant could claim an offset. That's not improper burden shifting. That's just the district court sifting through the evidence, resolving conflicts in the evidence, and arriving at a restitution amount. As a result, the defendant fails to show that the district court abused its discretion in this case.
They're arguing it's burden shifting because they're saying it's your burden to prove it was, here we go with my double negatives, not illegitimate. So I pled, defendant pleads to fraud, okay, over X amount. Now your job is prove that for restitution purposes, prove each check I took for services, as the senior justice mentioned, was not illegitimate. Where do we go for guidance that this is a matter of production and not burden of proof?
As the court pointed
Go
out,
for guidance that the process by which the district court followed was correct under New Mexico law.
first, Your Honor, I would argue that the plain language in the opening words of 31-17-1 gives us some guidance in that it directs that the statute be interpreted and administered to effectuate the policy that restitution be paid to victims to the extent defendants are able. We have that overarching purpose of the statute. We have the obvious spirit and reason of the statute. So to the extent that our state statute does not, like the federal statute, specify whether the burden's preponderance of the evidence and who must come forward with this and then who must come forward with this, our statute leaves all of that blank. However, the obvious spirit and reason of the statute is the same as the federal statute, and that is to.
I mean, I think B says it.
It does, and that this is more just a fallback position that I'm trying to articulate based on Your Honor's question. We have the obvious spirit and reason of the statute is to restore victims. Okay, there's some language. Could the statute be more clear as to how that plays out? Well, of course, but nevertheless, we can turn to the federal statute for rationale to help explain how the burden is applied. And
So you think I don't think what happened below was what happens in federal court. I think the judge actually looked at the evidence like judges do, had a long hearing and there was a lot of evidence, and decided what he thought was credible and what he thought was not. Of course, considering the defendant's plea, and decided, made a decision. And I agree. I don't think he necessarily abused his discretion. I don't understand why we're talking about shifting burdens and all that. I think it really is just what was the evidence and what evidence did he believe. He made a very detailed record. And in my mind, that's what the state's arguing. That you all went through the record, including the inferences that could be made. There's nothing that says the state has to prove each and every little thing. Instead, it's during this time period he pled to and the evidence presented. And I think the judge made a decision as to what he believed. I'm just wondering if you think we need to get into all this language from the federal act, or we can just do it the old-fashioned way and find out, did the judge abuse its discretion, and was there enough evidence in the record to support it?
that's a fair question, Your Honor. And I'd say option one is exactly as Your Honor put it. I mean, our standard of review is for substantial evidence to support the district court's determination. And there is more than enough of that on this record. And I think we can go just that far and full stop and resolve this case on those points. This court has ordered us to discuss the federal cases, and I did want to be responsive to that and address Justice Thompson's question. If we are to look at, federal authority, we could look to the federal authorities as support for the rationale behind why the state prevails in this case. We could go there if we need to. I agree with Your Honor that we don't need to.
Well, but what we often do is for other courts, we provide guidance as to what process they may follow. So Judge Lovelace and others aren't caught up in this. I'll make it up as we go. What is your view of the process? Start with what the state's obligation is at the restitution and the burden of proof?
The state has the burden of production. Once the state comes forward with some evidence to establish a prima facie case regarding the quantity of restitution and inherent in that, what if any quantity there may be for an offset, then the defendant has the burden to produce evidence that he feels or she feels supports the defendant's view of what that amount should be.
Doesn't have to put on any evidence, does he?
Right. I mean, but if he's claiming a position that's different from the state, then got to put up.
I agree.
And in the court's final determination of whether or not a certain amount of restitution applies, what is the standard?
I would frame that in terms of the standard of review, Your Honor. I would frame that in terms of, will there be substantial evidence in the record to support that determination? And if there is, then it will be affirmed.
What's the lower court's burden? Because that one case does, it seems like the state concedes its preponderance of the evidence, despite that older New Mexico case that suggested it's something different. Do you think it's preponderance of the evidence as we're providing guidance for the lower court? Everyone going forward, the standard is preponderance of the evidence?
I will clarify the state's position on that, Your Honor. The state does address in its briefing its belief that the standard involves the greater weight of the evidence. And I will stake out a position here that despite New Mexico precedent, equating preponderance of the evidence with the greater weight of the evidence, I would stake out a position here today that that is not necessarily true in these circumstances. When we are talking about the exact amount of a restitution award, there's a difference between preponderance of the evidence and the greater weight of the evidence. Here, the state is saying basically the district court ought to be determining these things based on the greater weight of the evidence. But the district court can do that without necessarily making a determination as to whether the preponderance of the evidence supports a specific restitution amount. I'll give you an example, and I don't mean to make light of the situation, but it's an example just from everyday life. Recently, I was on vacation with my son. We went out for a week and spent a lot of money on candy and ice cream. Now, if somebody asked me to approximate how much we spent on candy and ice cream, I could get together with my son. We could take testimony from each other. I could look at the receipts crumpled at the floor of my car. I could go through my bank records. I could estimate how much cash I spent. And I could come up with a few different views of what that evidence is going to show. One might be $80 in candy and ice cream. One might be $100. One might be $120. Can I say that a preponderance of the evidence supports one of those figures over the other? I can't. But I can say that the weight of the evidence shows that I spent at least $80 on candy and ice cream. In the context here of a restitution determination, can the court necessarily say by a preponderance of the evidence that the amount is $353,000 or $350,000, $355,000? Maybe not. But can the court, by the weight of the evidence, determine that it's $353,000? Absolutely.
Very first case where this court laid out the standard of proof.
Lack.
Thank you. You think just keep that as is?
There is no reason to upturn lack, and to be honest, defendant does not argue in the briefing that does not point out the stare decisis factors or the factors that a court must consider when upturning precedent. There's no argument on those points. And I would suggest that the court can resolve this case without even addressing that.
Also, if we did decide that lack was not where we wanted to be in restitution cases anymore, would we have to remand this case for a new hearing?
I don't think so, Your Honor, because the record in this case, I would argue right for any reason, the record in this case amply demonstrates or that the district court could have concluded by a preponderance of the evidence that the restitution amount ought to be $353,000.
Do you agree he could also have concluded that it was not the amount that he found? That it was the 50-some thousand that the defendant was not contesting, and only that.
I would argue, Your Honor, that there were varying levels of evidence that supported different subsets of amounts. Now, as to the 36,000, we had a concession from the defendant. So, and then there was another $53,000 where one way to put it is the evidence had defendant more dead to rights than as to the remaining $353,000. That evidence was indeed stronger, and there was more specific concrete links to fraudulent activity. But there was evidence supporting all of those amounts.
My question is, could he have found only 53,000 as restitution on this record, affirmed on the basis of supported by substantial evidence? Because the judge is the fact finder.
In theory, I believe yes, Your Honor. I would like to spend some time addressing some points that the defense, my friend on the other side, was making. Defense claimed there was no evidence that defendant fell under the regulations or the trust requirements regarding record keeping. I would suggest that this court can look at the testimony of Claire Logan, where she explains that defendant was there 20 hours a week, and that in caring for victim John for 20 hours a week, defendant was deploying his mental health expertise, specifically in psychology and addiction during that time. That's at August 6, 2019 CD 14440 to 14530. That type of service expressly falls under the administrative code provisions that operate on licensed mental health counselors and require them to keep records detailing the nature of the services performed and when they were performed. Also, the trust specifically requires, that's October 9th, 2014 trust, accurate, quote, accurate accounts and records, close quote. And in those provisions, they specifically discussed, quote, companionship care and medical and care management, close quote, specifically from the Logans. So those trust requirements and the requirements built into the administrative code did operate on defendant and did require defendant to keep adequate records detailing the nature of the services performed and when they were performed.
And the district court found that evidence credible because he mentioned it in his order about the fact that there was no reporting done by defendants. So obviously, that's evidence he considered in deciding whether the defendant should have to pay restitution.
Yes, Your Honor. And that takes me to a proposed holding that I would like to offer the court. It goes something like this. Whereas here, a defendant is guilty of fraud over an extended period of time, and the lower court receives evidence of fraudulent charging of an ongoing and or recurring nature during that time period, it is not unreasonable for the court to consider the absence of reasonably sufficient documentation as to the nature and amount of services billed as a factor relevant to its conclusion that those services were not legitimate and that the defendant therefore cannot receive an offset for them. We can cite the federal precedent for that rationale. Right, but it's basically common sense.
Yeah, well, okay. That's not in the statute, so, you know, you're arguing the statute. What about the defendant's Fifth Amendment right to not produce those records if they had them in a restitution hearing, post-plea?
I would submit that it's not an issue in this case. Nobody violated any Fifth Amendment rights of the defendant. There was no Fifth Amendment violation here. Defendant pled guilty. Defendant had an opportunity to present evidence to support his view of restitution, which is a sentencing matter. Guilt was not at issue. there's no Fifth Amendment violation.
Judge Lovelace wrote an order based on a fraud case. Victim restitution involves more than fraud. Is the test laid out either by Judge Lovelace or any test laid out by this court, test is a bad word, process, would that be limited to restitution and fraud cases or any restitution case?
I think generally it can be extended to restitution cases, generally.
I had a follow-up on the Fifth Amendment right question. If the defendant is testifying as to legitimate services provided to the alleged victim, does that trigger the Fifth Amendment right to not self-incriminate?
I don't believe so, Your Honor, because defendant is simply arguing for a lower amount of damages. That does not inculpate the defendant. On the point of what's in the statute and what's not in the statute, I would point out that this court routinely is called upon to interpret statutes that are less than clear on certain points. And we have statutes that direct that process. 12-2A20 from the Uniform Statute and Rule Construction Act talks about other aids to construction. It provides that there are several aids to construing statutes, and they may be considered in ascertaining the meaning of statutes. One is a judicial construction of the same or a similar statute or rule of this or another state. And I would argue that another state could also mean the federal government. Another aid is looking to the common law on the same subject. So by statute, this court can turn to these federal cases to fill in the blanks as to the details of how 31-17-1 should operate or play out in the district court.
So what language are you asking? I understand generally what you're saying, but there's no language that, in my mind, there's nothing that says about the burden changing to the defendant or the court having discretion. To me, the word burden, if we're going to be switching it over to the other side, or the judge has discretion to decide who has the burden, it seems to me the word burden should be somewhere in here, and it's not. So I'm wondering what you're referring to.
I would say at the very least, based on Carey and Bikundi, that we can say that where the defendant is in the best position to provide evidence to support the defendant's view of a restitution amount, then the defendant ought to have the burden to put up that evidence.
So you do think the statute allows, we can interpret the statute allow for the burden shifting? Because that's then what it would be, as opposed to, in my mind, this is the state put on its case, the defendant pled guilty to this time period. The state put on testimony and evidence, and it's up to the defendant whether or not he wants to rebut it, just like it would be in any trial. And except the great thing about this is he can put in, he doesn't have to testify at all. I mean, the rules of evidence don't apply. The defendant has that opportunity, but you're saying basically the court can compel them to, or just make a presumption. You're asking for a presumption that if it's unknown or uncertain, then the court can shift the burden to the defendant.
Not a presumption, Your Honor. I would say that based on the standard of review, it is not unreasonable for a district court to consider the fact that the defendant has not put up evidence to support his or her view on restitution. And again, this is part of kind of a fallback position if this court wants to wade into these federal cases as part of its analysis. That is the fallback position that the state would take. However, primarily, I would agree with Your Honor. This is just a matter of substantial evidence supporting the district court's determination, and therefore there being no abuse of discretion. Are there any other questions that I can address? Then I will sit down. Thank you.
Just very briefly, I'd like to respond to Justice Thompson's question about guidance. I think at its base, this is a purely statutory construction case, and you always start with the plain language. You have the language about civil actions here, which I think lends to the standard, the burden. And then you have, as Justice Thompson pointed out, some section B. But I maintain that that applies to plans of restitution, not the hearing or evidence required. And then if you read B in conjunction with E, the determination of actual damages has to come before the plan of restitution is even put in place, because it has to contain what the actual damages are. I would also like to address the preponderance of the evidence as the standard. So that's more likely than not. And if it's not more likely than not, then is it less likely than not? Or is it even? And I don't think that was contemplated by the legislature in 3117.
Did you ask us in your briefing, did you go through the factors to overturn LAC? Because LAC clearly does not say preponderance, it says something else. Did you go through those stare decisis factors and ask us to overturn LAC?
I do not recall that. LAC was a Court of Appeals decision. That's, I think, why.
Okay.
I think they're all guidance is Court of Appeals decisions.
Okay, so you're
which is
just
why we
saying-
didn't go.
Got it.
It's not your, yeah.
Good point.
You're in charge.
Good answer.
I have nothing else unless.
Well, why shouldn't we just keep LAC in place? This isn't much, this is not like other situations in the criminal, the whole proceeding of a criminal case. I mean, it's the restitution determination. It is much more lax. The rules of evidence don't apply. The court has a ton of discretion in sentencing. Why wouldn't we just keep LAC in place? And I think the state made some good arguments. It has me thinking maybe there's no reason to depart from it.
I think that there's a couple answers to that. One is, again, going back to the statute. What does the statute say? I think the second one is, I think the courts are confused. I think if you look through how Judge Lovelace was talking out loud, trying to figure out what he was supposed to do under LAC, Madril, and Rodriguez, he was confused. I think everyone was under LAC, and I think the lower courts and all the parties would benefit for some clarification.
So either keeping LAC and saying, this is the standard, we agree, or else going to preponderance. But either way, just making real clear for the trial courts what it is.
Yes, and I think part of the confusion is LAC about what does that mean? What is that burden asking for? So I think LAC created some of the confusion here.
So can we, if we were to decide that LAC was not good law and that we wanted to adopt a preponderance of evidence standard, can we just go and review the record, the evidence that was presented at the restitution hearing, and decide whether it meets the preponderance standard, or do we have to have a new hearing?
So I would also add, as a caveat to that, that the Judge Lovelace found that there was not, that it was a murky causal connection, that the state had not even proved this strange lower standard that exists under LAC. So I don't know if we believe him about what he found, then then there was no preponderance of the evidence.
So you think we can just rule based on his conclusion that it was murky and that does not equal preponderance, and so that's not included in the restitution order?
Right, so it would only be the 36,000 he stipulated to, or on the other hand, or as an alternative, if you decide this is new law going forward, then in fact, Jim Logan had the burden to put on some evidence to prove that these were legitimate, we would ask for a rehearing so that he could operate on that assumption along with the judge and the state, everyone on the same page that that's what he has to show.
What if we say it's not a burden, but he has the opportunity to rebut it?
I think that's already true under the statute. Yes. If there's no further questions, thank you for your time.
Thank you, counsel.
Thank you.
We will take the case under advisement and give you an opinion as soon as we're able to. On behalf of the court, I thank both of the parties for their briefs on this case. They were very informative to the court, and your arguments this morning, it's going to be afternoon, were also very informative. And thank you. We will take the case under advisement.
Attend the court, please.